Good morning, everyone, and welcome to the UKH webinar on preventing sexual harassment, dealing with some new legislation that's coming into effect from next month, and that members will be keen to be aware of. We have here experts from both ACAS and from the Equalities and Human Rights Council, and I'll pass over to them in a minute for some detail. They will provide you information on what the law says and what you need to do as businesses. It's clearly an incredibly important topic for hospitality. There's obviously the compliance issue, complying with the new law, but it's also very much about protecting our team members and helping to promote the sector as a great place that people want to work. And I think we'll touch on that shortly. We have a Q&A function, so please feel free to put questions in to the Q&A. I believe that's at the bottom of the screen for most people. Just to say on that, our speakers are apolitical. We can't have any political views, and they're also bound by sort of an inability to give advice on specific instances for sort of obvious legal reasons. So please, if you are framing your questions on specific instance, can you make them more general rather than specific instances that have happened, because we won't be able to deal with those. Next slide, please. Here are our speakers. Myself, just doing the intro. We've got Rebecca Thomas, who's the head of employment policy, who I'll hand over to us in a second at the Equality and Human Rights Commission, and Julie Dennis, head of inclusive workplaces policy at ACAS. Next slide, please. Just in terms of the context of this, this piece of legislation was passed by the last government. As we'll all be aware, there's now a significant focus on broader employment rights with the new government. I think it's just worth focusing on where the current government is. This quote, "Our imminent employment rights bill will deliver the biggest upgrade to rights at work for a generation and is a vital step in the delivery of the Make Work Pay plan." So I think it's important to realise that's a new government policy and that's where we are. But this is sort of the direction of travel in terms of making work a safe and desirable place for people to go. So that's and as you'll know, UK Hospitality are working very closely with government on the forthcoming employment rights bill that looks at bans on 0 hours contracts, bans on unfair dismissal, day one rights, statutory sick pay reform, all of that sort of stuff. So we'll be working on that. But this webinar is specifically focused on the issue of sexual harassment and prevention thereof. Next slide, please. And on that note, I will hand over to Rebecca Thomas.
Thanks very much, David. Good morning, everyone. Thanks so much for the invite to speak to you all this morning. We're really interested in the work that UK Hospitality does, because we're aware that issues related to sexual harassment sort of continue to be particularly prevalent in the hospitality industry. And we know that many employers are really concerned about this issue and what they can do to address it. And we have a long-standing relationship with UK Hospitality. We produced resources a couple of years ago. A checklist and toolkit for employers who wanted to sort of consider and address the potential for sexual harassment in their workplace. So what I'll do, though, is that I'll start with a little bit of background for you. So as David said, I'm Rebecca and I'm head of employment policy at the Equality and Human Rights Commission. I've been leading our work on sexual harassment in the workplace for a number of years now. The EHRC is a statutory body and we enforce the Equality Act 2010. We're also an A status national human rights institution, so we also sort of monitor compliance with various sort of international human rights obligations. But in relation to equality law, I think it's worth emphasising at this point that under that act, which has been in force for 14 years now, sexual harassment has always been unlawful, and employers should already have been taking steps to prevent workers from being sexually harassed. Otherwise, they are liable if an employee has experienced that and decides to take a claim to the employment tribunal. If I could have the next slide, please. What I want to do is to sort of talk a little bit about the policy context that has led to this legislative change. So as we saw after the Me Too movement back in 2017, harassment at work, particularly sexual harassment, was really widespread. So the EHRC ran a call for evidence and we got thousands of responses from both workers and employers, which gave us a number of insights into why the legislation that had been enforced for a long time wasn't working effectively. And one of our main findings was that employers tend to deal with any instances of sexual harassment if and when they arise on a case-by-case basis, rather than taking proactive steps to ensure that they're creating workplaces where sexual harassment doesn't happen in the first place. And we saw a lot of inconsistency in employer responses in response to those individual cases too. The other big finding we had was that we know many women don't report their experience of sexual harassment because they're worried about repercussions, not being taken seriously, or being penalised because they make a complaint. So as a result of this evidence gathering, we made a recommendation that government make it a requirement for employers to take proactive steps to protect workers from sexual harassment. So I'm just aware that the slide hasn't moved on. Could you move it on, please? Thank you. That'll give you hopefully a little bit of a summary of what I'm talking about. And we also made a number of other recommendations, one of which is for our lovely ACAS colleagues as well. But ultimately what happened as a result of this work and sort of other organisations and bodies sort of campaigning to strengthen protections in this space, we secured a commitment from the government to strengthen protection against workplace sexual harassment. Could I get the next slide, please? Yeah, the next one. Sorry, apologies. I have too many holding slides. So the Worker Protection Act, this was a private member's bill that was introduced back in 2023 with government support and actually cross-party support. And I think that's particularly important to say. All political parties supported this. The private member's bill was taken by a Liberal Democrat MP. It was supported by a Conservative government, and the Labour Party also supported it. And what this does is introduce a preventative duty on employers, which basically shifts responsibility to the employers to take positive and proactive, reasonable steps to prevent sexual harassment of their workers. And this new duty comes into force on the 26th of October, which is one of the reasons we're speaking to you all today. So what the duty means is that employers will need to think about how sexual harassment could occur in their workplace and take preventative steps to mitigate the risk. And this really is sort of an important cultural shift from redress to prevention, and would send a clear message to all workers that they are protected from unlawful harassment. Now, it's just worth sort of reminding the definition of sexual harassment. So that's unwanted conduct of a sexual nature which has the purpose or effect of violating a worker's dignity or creating an intimidating, hostile, degrading or humiliating environment for that worker. The Act also enables the EHRC to take enforcement action if an employer breaches the preventative duty, and the Employment Tribunal can also increase compensation in a sexual harassment claim by up to 25%. Now, the preventative duty also includes harassment by third parties, and the reason for this is that the way the legislation is drafted means that the employer is obliged to protect its workers from any sexual harassment, I'm using bunny ears, quotation marks, in the course of their employment. So this means that harassment that takes place in the workplace, but also other places where a worker is working, for example, working from home, attending an external meeting, conferences, work social events sometimes, it is covered. But the legislation also doesn't specify that employers are only liable for harassment committed by its own workers. So this means that the preventative duty includes sexual harassment committed by third parties, as long as that harassment happens in the course of employment. So a third party is somebody like a customer or a client or a patient or, you know, whoever, different ways in different types in different sectors. So in order to comply with the duty, employers therefore need to make sure that they're taking reasonable steps to prevent sexual harassment by third parties, as well as sexual harassment by their own workers. What I do want to clarify, though, is that if an individual is sexually harassed by a third party, they cannot bring a claim of third-party harassment to the Employment Tribunal. There's no standalone claim for an individual. But this is where the compensatory uplift occurs, is that if there is potentially a breach, sorry, I beg your pardon, no, that's not relevant for this, but if there is potentially a breach in relation to third-party harassment of the preventative duty, we can take enforcement action. So can I have the next slide, please? obviously, we can't just sort of see a new duty come into force and then expect people to kind of run with it. So, as I said at the start, the EHRC and the UK Hospitality have been working in this area for a number of years already to ensure that hospitality sector employers are aware of their obligations under current legislation and understand what types of action they can take. And I know that Julie is going to talk in more detail about the specific types of practical, reasonable steps that employers can take to demonstrate compliance. But from the EHRC's perspective, we also have a responsibility to produce resources for all types of employers so that they understand their obligations. And to that end, we have just updated our existing sexual harassment and harassment at work technical guidance, and that's going to be published very, very shortly. So I will ask UK Hospitality to share that with people who signed up for the webinar. And we've also produced a short form 8 steps guidance. And this outlines sort of 8 key steps that we think are necessary for employers to take in order to demonstrate that they're complying with the duty. Now, none of this is prescriptive, as you would have seen on the earlier slide. What's reasonable will vary employer by employer, and it will vary sector by sector. It depends on the resources, it depends on the risks that you identify. But no employer is exempt from the duty. Everybody needs to do something. So what we're producing are resources that will essentially act as a springing board for the for you as employers to consider and sort of identify what might contribute to the risk of sexual harassment in your workplace. Can I have the next slide, please? And just to provide a bit of reassurance, obviously, because I've talked about the EHRC as a regulator, as an enforcement body, and the fact that the Act gives us the power to take enforcement action. I don't want people to think that, straight away from October the 27th, we're going to go all out in, taking legal action against people. All of the work that I've outlined already around the kind of the guidance that we've been producing, the engagement with different partners, is a fundamental part of our regulatory approach. In terms of where there might be breaches of the new duty, we're very much going to take an intelligence-led approach. That means we need to work with ACAS and UKH and others to generate insights to understand how employers are responding or where they might be struggling, so that we can look at sort of producing further resources or targeted interventions to support compliance. However, we do have the power to investigate and enter into legal agreements where there might be sort of continued non-compliance or really sort of grievous breaches of the preventative duty. And some of you might be aware, for example, we've had legal agreements with organisations like McDonald's and Sainsbury's because of failures to address sort of persistent or systemic sexual harassment in their workplaces. But at this point, it's very much about how can we support employers to understand their obligations under their new duty, sort of explore what might be reasonable for them in this space, and to ensure that they are, as David said, sort of creating workplaces where people want to go, where they can thrive and when they feel safe and supported. So I will pause there. Thank you very much. And I will hand over to Julie, who will share further insights. Thank you.
Thank you, Rebecca, and good morning, everybody. I'm Julie Dennis. I'm the Head of Inclusive Workplaces Policy at ACAS, and I'm delighted to be joining this webinar today to hopefully give you some tips on how you can start looking at taking those reasonable steps to prevent sexual harassment in your workplaces. So before I start, just a very brief overview for those of you who don't know ACAS are. We provide free and impartial advice and guidance to both employers and workers about their employment rights. And that will include stuff around sexual harassment. And my team, we lead on work around sexual harassment. And I've been working with Rebecca for quite a few years now on this subject. And it's an area that I'm actually really passionate about. I've been working in this field quite sadly for 20 years. And it's about, what can we do now to create environments where people can come to work and work in an environment free from harassment. Next slide, please. So I thought what I'd do first of all is just give you an overview of how workers experience sexual harassment in workplaces. Do you want to click this? That's it. And the second one. Thank you. So what we know at ACAS from speaking to people on our helpline is that sexual harassment has a real impact on someone's self-esteem and can prevent them from progressing in their career. And in some circumstances, it can actually be career ending. So it's about looking at how we can prevent that rather than deal with it when it happens. And this is a real positive step that employers can take. Now, when people phone our helpline, when they've experienced sexual harassment, they tell us what has happened and we'll discuss their options with them. And the options normally are, first of all, try and raise the issue informally. Now, we recognise that's not always, a situation that people can do, but we know at ACAS that informal resolution is the most effective way. If informal resolution doesn't work, or if they can't do that, consider raising a grievance. There's obviously, if you're not happy with the outcome of that, consider an employment tribunal. But one of the most important things as well that we advise callers is to seek additional support, such as counselling, when they're going through that situation. But even after our helpline advisors have spoken to someone about their options, often people who've experienced sexual harassment are unwilling to take action or report it. And this is because either they don't feel they'll be believed, especially if there's no witnesses, or there's a power imbalance between them and the perpetrator. They don't want to be seen as a troublemaker, so they feel if they make a complaint, they'll have a mark against their name, and they'll be passed over for opportunities or treated badly. They may feel that the issue's not serious, or that no one will take them seriously, or they may feel that if they do report, well, nothing will change, so why bother? So many people who experience sexual harassment at work will take themselves out of the situation. So that may mean they'll leave their job rather than reporting it. And the problem with this is it can leave employers unaware that there's actually an issue that needs to resolve. So what we're trying to encourage organisations to do is that we have a move that employers are more proactive on this issue. So because as we know, it has many benefits, and employers will be able to work without fear of harassment in the knowledge that we're dealt with appropriately. And if it does happen, that employers will not risk losing valuable staff members along with the recruitment cost to replacing them. Next slide, please. And can you click to get the 4 things on? Thank you. So I thought I'd also touch on how does sexual harassment manifest itself in the workplace. Most of you on the call will probably know this, but I just thought it'd be good to reinforce it. So put simply, we're focusing on conduct of a sexual nature, and Rebecca's already outlined that when she's talked about what the law says. Now, when we're looking at sexual harassment, it covers verbal, non-verbal and physical conduct. So this could include things like sexual comments or jokes, and that can be face-to-face, via emails or social media, displaying or sharing pornographic photographs or drawings, suggestive looks, staring, leering, making promises in return for sexual favours. So, for example, I can give you extra shifts if you do this for me. It could be around asking someone about their personal, private or sexual life, making sexual gestures or remarks of a sexual nature about someone's clothing or body appearance, propositions, sexual advances, touching against someone's will, including hugging. And on the extreme of this, we're looking at sexual assault and rape. So my first tip is, as part of the preventative duty, as an employer, you should list the types of behaviour you consider unacceptable. So all of your workers or staff have a clear understanding of the types of behaviour that will not be tolerated. And you should make it clear to everyone who works for you that sexual harassment is unacceptable at work, it's against the law, and that complaints will not be ignored or covered up, and the misuse of power in the workplace in relationships, for example, through seniority or influence, will not be mentioned. I think it's also important to mention that harassment can come in different forms. So it could be a one-off incident. Some people think that it has to be repeated behaviour, but there's been a lot of employment tribunals where it's just been one incident and that has been found deemed to be sexual harassment. Of course, it could be repeated behaviour or a course of conduct. There's also indirect harassment. So this is around creating that toxic atmosphere. So someone may say something that's offensive, but the person they say it to isn't offended, but someone else in that vicinity finds it offensive. So that would also be seen as harassment. And then, like Rebecca touched on earlier on, it can happen in different places to the physical workplace. So, for example, at work parties, social events, colleagues, or through social media. And it's quite interesting when we get, we're coming to the end of the year soon, and December and January is when we see a peak in calls to our helpline around this subject, because we have the lovely Christmas parties where sometimes people have a little bit too much to drink and end up behaving in a way that's inappropriate. So it's about being aware that it's not just about what happens in the workplace. And finally, I think it's really important to acknowledge that harassment can happen to anybody. It's not just a female issue. It can happen due to someone's sexual orientation and inappropriate comments about someone's sex life, whether they're gay, straight, or bisexual. I think it's also important to note that it's not always a power imbalance. There's this common image that, sexual harassment is that older male manager harassing that young apprentice, and the abuse of power that comes with that. And that is very common, but it can happen from anybody, so it could be someone at the same level as the person being harassed, or even someone junior to the person being harassed. Also, just because something's been allowed to happen doesn't mean it's right, or that people can't make a complaint because, well, this is how it is here, or, well, we all know about X, and, just stay out of their way. Managers should not be allowing inappropriate behaviours, and they certainly should not be be actually the ones that are doing it in the first place. And I think the main thing to make clear is that everyone should have the right to go to work and be treated with dignity and respect. Next slide, please. Can you click to make the things come up? That's perfect. So the impacts of sexual harassment at work are not just limited to tribunal claims. Now, we know apart from the emotional and social costs of sexual harassment, it can also impact on the bottom line in the workplace. And harassment in the workplace can lead to absenteeism, increased turnover, lower job performance and productivity. Victims of sexual harassment may not be able to function at their normal productivity level. And if perpetrators are successful in blocking victims from advancing within a company, the company is losing out on the best candidate for a given position. And additionally, dealing with sexual harassment incidents and their impacts take time away for managers to complete their other tasks. It also decreases employee morale, and the threat of sexual harassment can create in more, stress, and like I say, it impacts on that morale of your workforce. Staff turnover is another issue, and you'll see that you've got some real talented people that leave your company because they're working in this hostile environment. And it's not just the people who were subjected to it. Witnesses and observers may decide, I'm going to leave because I just don't like this environment. And I don't need to tell you about the cost incurred by toxic environments, sick leave, health benefits, monetary damage, award to victims, legal expenses, they all add up. Plus, let's not forget the negativity of publicity. Now, it's easy, as we've seen now, for things to go viral for all the wrong reasons, and it doesn't require a journalist to report in the newspaper anymore. And the impact of that could mean that you're, losing out on attracting really good talent into your workplaces. Next slide, please. So what are the practical steps for you to take? So I've outlined to you what sexual harassment is, and I thought to just talk about some of the practical steps you can take for your workplaces. So first of all, if you're looking at the new duty and what reasonable steps are, completing risk assessments should be one of the first steps you look at. And this simply is about evaluating whether certain jobs or certain situations may increase the risk of someone being subjected to sexual harassment. So, for example, how rotas are planned, or how staff tips are allocated, or if you have any staff who are lone workers. So once you've identified those risks, you should look at how to eliminate and reduce them. So, for example, if possible, not just having one person responsible for deciding rotas, Or if you have a lone worker, ensuring that they're aware that if sexual harassment is experienced, they are to leave that environment immediately, report to the manager, who will then provide the appropriate support. Secondly, at ACAS, we'd advise that employers should have a policy about sexual harassment. Now, we recognise that for smaller businesses, that may not always be possible to have a separate policy. So it can be contained within your existing policies, for example, a dignity at work or your discipline and grievance procedure. And one of the things that we know at ACAS is the best policies we've seen have actually involved its staff in the development of that policy. Now, there's a few key things you need to make sure you have in that policy. So first of all, it's setting out, what is sexual harassment? So everybody's on the same page. They know what unacceptable behaviour is. But it's making sure that you can't list everything. So it's about saying this gives you a flavour, but obviously there may be other things that may fall into that. It's also really good if you put a statement in your policy, telling staff about the standards of behaviours, which again will make it easy for everybody to know how they're expected to behave. Now, that might seem a bit like teaching people to suck eggs, but believe me, the stuff we hear at ACAS sometimes we just have to remind people how they are expected to behave and things they shouldn't be doing in the workplace. What's really important in your policy is outlining what the complaints procedure is, so everyone's clear what they can do if they are subjected to it. So that's about looking at the different options that people can turn to if they feel they are being harassed, and who they can speak to. So this could be someone like their line manager, a more senior manager. You may have staff who are specially trained in your organisation to deal with sexual harassment, and those that are trade unionised, the individual may want to talk to their trade union rep. And you should also set out your informal options for dealing with sexual harassment complaints. So that could be, for example, that the person may speak to their line manager, and their line manager will talk to the individual and have that informal conversation, highlighting why the behaviour was unwanted, hopefully get an apology and an assurance that they will never do it again. You also may need to make sure that you outline any formal procedures that you have for dealing with sexual harassment, and they should be used either if the informal options not worked, or where the individual wants to make a formal complaint, or actually the matter is so serious you're going to go straight to formal. Plus, the policy should be clear of what the process is, such as, an investigation will take place and whether the employer will follow their disciplinary procedure or a separate procedure should evidence be found that sexual harassment has taken place. And the policy also should state that, for individuals that have been subjected to sexual harassment, that you'll give them time off to get help, resulting in any physical or mental health problems. You should also include in that policy that it applies to staff working on and off the premises. So like Rebecca was talking about earlier on. So that includes those who are working away from base. And it should also cover that sexual harassment of staff by visitors to the organisation will not be tolerated. And that would include customers and stuff like that. One of the other things that's really important is you let people know about the policy. It's no good having this fantastic policy and then it just sits in a shelf in HR and no one knows about it. So, actually have make people aware of it, encourage people to report sexual harassment if they're experiencing it or witnessing it. And also by publicising it, again, it gives you the opportunity to set out what behaviour is acceptable and what is not. And most importantly, what steps your people can take if they believe they're being sexually harassed. Now, a policy in itself is not the only step to take. So staff training that enables staff to recognise and challenge sexual harassment when they see it is also a key component. And training should be regular. So don't just think, we'll train people and then we'll come in and then that's it. And 5 years later, they've had no training. It's really important to regularly revisit your training to make sure that your staff are given the tools and confidence to challenge inappropriate behaviour. And also training will increase everyone's awareness of the damage sexual harassment can have to both the organisation and the individual. At ACAS as well, we'd say it would be really good practice if you do separate training for line managers in relation to how they respond complaints and the details of the internal processes. And this will make sure that managers have the skills to have those difficult conversations and manage those procedures. Now, I've already highlighted that having a clear complaints procedure when I talk through what should be in your policy, but it's really important that any worker who feels that they've been sexually harassed knows what the complaints procedure is, and that all complaints of sexual harassment should be taken very seriously and handled fairly and sensitively. As I've already said, sexual harassment is often extremely emotional and distressing for everybody involved. So this means that an employer should make reporting the matter as stress-free as possible. And in most cases, this includes making sure that there's plenty of time to discuss the matter with the individual and you find a private space to have that conversation. Employers must allow the worker to be accompanied by a work colleague or a trade union rep if you're going down the grievance procedure. And sometimes, you may want to allow someone to be accompanied by a friend or a family member, but that's only if the employment contract permits that, or it could be at the discretion of the employer. And remember, if the complainant has a disability, then you need to also think about, are there any reasonable adjustments we need to put in place as part of the grievance procedure to make sure that that individual has full access to make sure that they're being able to tell you what has happened. All complaints should be handled consistently in line with existing policy and procedures, and of course, in line with ACAS's discipline and grievance code of practice. Now, you need to make sure that complaints are dealt with properly, and if there are any delays with the process, you need to make sure you keep all people informed so they know that things are happening and why there's delays. Confidentiality is another key element of that process, so you should keep the complaint as confidential as possible. And you need to make sure that information is only shared with the relevant people, so the complainant, their rep if they've got one, the person accused and the investigator. And you need to explain to them why it's really important. And that includes explaining that to any witnesses, because again, if they start spreading rumours, that can, harm the environment, and it could also damage the investigation. When you're handling that complaint, it's really important that you don't judge what the individual's saying and stay focused on the behavioural acts and the effects. And this will ensure that you can remain impartial. And it's also important to support for both the complainant and the accused. So, if you've got a EAP or, a mental health support program or something like that, you should offer that to both parties at the start of that process. Now, some types of sexual harassment are also criminal offences. So if you're looking at sexual assault, stalking, indecent exposure, etc. So employers should support the individual if they want to go to the police, but they shouldn't pressurise them to do so. Now, if an employee wishes not to report to the police, in most circumstances, you should go along with that. However, there may be circumstances where you feel you do need to go to the police. So if there's an ongoing risk to that employee's safety or the safety of others. But before you go to the police, you should make sure you make that person aware. And you should also let them know once you have told the police. Just to note, though, a report to the police does not normally stop an employer conducting their own investigation under their discipline procedure, though you may want to check with the police that it won't prejudice their investigation. Now, whether or not a complaint is upheld, it's good practice to undertake an evaluation after you've done your investigation of a complaint of sexual harassment. And it's good to consider whether the preventative steps that you'd already put in place were good enough. And one of the things you may want to do is revisit those risk assessments you did and take into account any actions that may be necessary to prevent further occurrences. And remember, the preventative duty is not a one-time thing, because so complaints should trigger an employer to reevaluate the steps they've identified. Once you've done that, I'd recommend you consider what message you want to communicate to your workforce. So reinstating that sexual harassment is not tolerated and the reports are welcome and they'll be dealt with appropriately. And also, it may be really good practice to just refresh your training, just seeing if there's anything else you want to put in place in the training and re-roll that out. Finally, once you've done that review, you may also wish to survey your staff anonymously just to see if there are any risks that still exist. Don't rely on looking at, well, we don't get many complaints coming forward. Again, as I said earlier on, and Rebecca has also said, a lot of people don't report sexual harassment. So doing those anonymous surveys will give you a really good understanding of what's happening in your organisation. I think it's also important that I just cover that, you need to make sure that even though you may have finished the investigation, it's really important to still think about those people who've been involved. And that includes witnesses and even those who handled the complaint. Sometimes we forget about the impact it can have on the person doing the investigation. So again, just reiterate to those what support is in place and whether they need support within your organisation or other places you can refer them to. It's also important to note that, sometimes not, sexual harassment investigation doesn't always result in someone being dismissed. So, they may have been, you may have found evidence, but actually it's not to the level where they're going to have to exit the organisation. So you need to think about how you're going to integrate that person back into the workplace. So you need to be really sensitive to everyone and balance the needs against those of the business. Now, one way you may want to do that is mediation, because that's a really good tool to use. And especially if the complaint's not upheld, mediation can help. And ACAS can help with that. And there's more details of mediation and support we give on our website. Next slide, please. So finally, before I finish, I just wanted to note that no matter what policies, procedures or training you have in place, we know at ACAS there's still barriers into reporting sexual harassment, which can focus around shame and lack of trust. And there's also a lot of onus still placed on the individual to report it. Cultural change is what's really needed. And this is why at ACAS, we favour a facilitative approach, working with employers to identify their own barriers, challenges and culture and find solutions at work. So in summary, when dealing with sexual harassment at work, prevention is better than cure. Engaging with your employers on issues and raising awareness around zero tolerance for unacceptable behaviour is a key way to avoid incidences in the first place. And as we know, a workplace which values difference, is free from hostility and based on tolerance will enable people to contribute more effectively and achieve higher levels of job satisfaction. So it's about striving to develop that culture where sexual harassment is unacceptable, that complaints were dealt with promptly, seriously and discreetly. And employers, and in particular line managers, should all be encouraged to play their part in making that a reality. So being prepared to challenge inappropriate behaviour and take action if you observe or have evidence that someone is being harassed. Alongside those policies, employers should promote the importance of respect between individuals at every level of the organisation. And, if you're wanting to deliver really lasting change and really go into the spirit, what the duty is all about, it's about also recognising the really powerful roles that allies can play, because that will help, again, create that environment where it's not focusing on the individual having to report it. It's about colleagues and bystanders speaking out, and that way that we can create those more in work environments where zero tolerance across workplaces is what is not acceptable. The key thing is we truly want to avoid sexual harassment instances happening in the first place. Thank you for listening. And I'm going to pass back over to David now, I think.
Thanks, Julian. Thanks, Rebecca. Really insightful presentations there on sort of the framing and how people go about dealing with the legislation, but also the issue more widely. And I think it was very clear what the benefits are to tackling sexual harassment in advance. So that really helpful. I had a few questions in advance, but please feel free to put questions into the Q&A, which is at the bottom. The first one that came through on the Q&A was the obligatory, are we okay to share the slides? Yep. Okay, that's the easy one out of the way. Great, we'll make sure those slides are circulated, and a copy of the webinar will be on the webinar on the website. Really struggling with those two words today. A question we had around risk assessments, I think you made quite a big piece of that, Julie, in terms of how important they are. Would you regard that as a mandatory requirement for a business to carry out a risk assessment?
I can come on in terms of what's in the legislation. There's no mandatory requirement to do a risk assessment, but employers will be required to demonstrate that they are complying with the duty. And one of the best ways they can do that is by taking a risk-based approach and by assessing risk factors within their workplace and developing an action plan. And if you look at the EHRC UKH toolkit and checklist, that clearly advocates a risk-based approach to do that. So I think EHRC and ACAS are very much aligned in terms of this approach, because ultimately it's going to provide clarity. It's a really good platform on which to engage your workforce and make sure that you are considering risks that you might not have been privy to as an employer, and to sort of develop kind of measurable, specific, reasonable steps that will hopefully prevent or reduce the potential for sexual harassment harms.
Yeah, I'd agree with what Rebecca's just said. And, ACAS ourselves, we're an organisation. We have over 1,000 employees. So we're looking at the preventative duty as well, and we're revisiting our risk assessments because we do have staff that interact with customers. And unfortunately, like a lot of you on the call, we sometimes have customers that think they can do certain things. So those risk assessments, I think, just really stand you in good stead. Should you end up at the worst degree that you're in a tribunal, that you're able to demonstrate, look, we've tried to do everything possible to mitigate that risk. And you do risk assessments for other things, so why wouldn't you do that for sexual harassment? To us, it just makes good business sense of making sure that all of your workers are safe in that environment. So yeah, we'd advocate they are a good thing to do, but they're not mandatory.
Great. Just following on from that, a question on are there sort of general examples of best practice risk assessments that are available, either that you guys might have produced, and I'm thinking, is there something potentially, if there is a gap, then UK Hospitality could look at working with you guys? I mean, actually, just to flag, Rebecca, you mentioned the toolkit. I think that's being updated, isn't it? Which will circulate to all members in due course. But yeah, just a question on sort of best practice risk assessments, or is the toolkit one?
I would very much sort of promote that. I think, and importantly, because it was developed in consultation, it was tested by hospitality sector employers. So we are really confident that the principles that are set out there, the types of issues that this sector experiences, are considered and addressed within that. And absolutely, I mean, I think it's sort of regardless of whether you've done it now, or you're thinking about what you might need to do in the coming months in relation to the preventative duty, that provides a really good framework of the types of things that you're going to need to consider as an employer.
Great, thanks, Rebecca. And as I said, we'll make sure that that's flagged up to people afterwards. That toolkit is on the UK Hospitality website. It may not be particularly prominent, but if not, regardless, we'll make sure that we link to it in a follow-up communication. So we'll make sure that people have access to that. Rebecca, I think it's you that touched on third parties, and I think you did a bit, Julie, as well. Is that defined in legislation, what a third party is, or is that sort of for you to, as a business, to identify yourself?
There's no formal legal definition of what constitutes a third party under the Worker Protection Act. The way the EHRC is looking at this, it's very much about the sort of those parties that you would come into contact with during the course of your employment, who are not workers, who are not who the employer wouldn't directly be liable for under the kind of the existing provisions. But if you look in terms of the kind of hospitality industry, it is very much going to be around sort of customers, it's going to be around suppliers, it's going to be around contractors who might be working in the business to do a particular activity, or it's sort of a short-term activity. And obviously we can't be prescriptive in terms of identifying who those third parties are and what risks that might throw up. And that's why, as you know, as Julie said, and as I've said, you know, that's engaging with staff, understanding their experiences, where their interactions are, what insights you can get from, you know, UKH as a representative body too, in terms of how sexual harassment might manifest in relation to third parties, is a really good way of sort of understanding the potential for risk, and then sort of identifying practical reasonable steps that you can take to try and mitigate.
And I think, to just follow up on what Rebecca said, you know, depending who the third party is, there's different ways you can deal with it. You know, sometimes it may be difficult to deal with the customer in the way that you want to. But, you know, if we look at contractors, you know, Rebecca's just talked about contractors, and when I talked about your policy, it's talked about visitors. So you may have an instance where there is, so I'll give you an example. I've come across during my career that, you know, I know of one case where there was the company had contracted a third party to do their cleaning and clean the windows and stuff like that, and a member of staff in that organisation who worked for that organisation was sexually harassing a member of staff in the main organisation. And what that company did was they contacted the third party organisation and raised the complaint, and that third party organisation took the individual, they took on the investigation, did the procedure, and then dealt with that individual through their procedures rather than you doing it. So, you know, that's another thing, making sure, you know, when you're so another reason of doing those reasonable steps is when you're tendering for services, making sure it's in that tender document, you know, that, you know, your employees will be expected to work in line with our policies and procedures, and also have that conversation. So you'll have a contracts manager that has those regular conversations to be able to flag that up and say, actually, if we have this happen, what is the procedure that we're going to take? Because I think a lot of companies sometimes get confused when it's not actually their employee, but it's a contractor. You know, again, they will have to work through their own policy. And I know the incident that I dealt with quite a few years ago, thankfully that third party supplier had a very, very clear policy, were very open to dealing with it, and they actually resolved that issue. I don't know what happened to the individual, but I certainly know they never worked on our site again. So you can read into that as you want, but it's about using those other processes.
Thanks, Judy. Just a question on enforcement, Rebecca. I think in my mind, the sort of enforcing a preventative action. So if I was working within a business, a hospitality business, and I felt that my employer did not have enough preventative measures in place, so no sexual harassment has taken place, but I feel that I'm at risk potentially because there aren't preventative measures, would I then come to EHRC to say, I think there's a risk here because no prevention has taken place?
So the short answer is yes. What we would always recommend is that you try, the individual worker tries to raise that and resolve that with the employer in the first instance, and certainly from the EHRC's perspective, that's what we would ask. A breach of the preventative duty can be dealt with under whistleblowing procedures. So the EHRC is a prescribed body for the purposes of whistleblowing. So where there are concerns about sort of discrimination or harassment, including sexual harassment, individuals can whistleblow to us, and we will then sort of triage and consider what action might be required. And, you know, in the first instance, we are really mindful. I think it was interesting, some of the survey insights that you've been generating in relation to this. There is sort of varying degrees of knowledge around the preventative duty. And in the first instance, it might simply be that the employer does not know that there has been this legal change, and there is that, you know, there is a requirement for them to kind of get their head around this and consider, you know, as Julie said, sort of going back and reviewing what they already do with a view to making sure that it's updated to reflect the change in legislation. So that's one scenario, and then, you know, there are going to be sort of, on a sliding scale, degree of sort of failure or breach of the preventative duty. But yes, individuals can certainly raise concerns with the EHRC via our whistleblowing mechanism.
Excellent, thanks. And I suppose sort of taking it that step further, you've done your preventative stuff, but you've got a rogue employee who has gone through the training, ignored the training, ignored the policy, ignored any signage, ignored their contract. I assume at that stage, you still, as an employer, even if there's not a complaint, you as an employer, if you're aware of this, you must take action.
Yeah, I mean, that's what I covered already. And I think it's really important. I think one of the things, if we wanted to really create environments that are free from sexual harassment, we've all got a role to play on this. And I think the thing that sometimes me and Rebecca, like I say, we've been working in this area for too long. And what really frustrates us is the onus is always on the individual that's been subject to it. You know, and as line managers, as business owners, you have a real role to set that expected behaviour. So you shouldn't wait for someone to make a complaint, because as we know, sometimes people won't make a complaint because they're frightened of the repercussions. So you know, what I'd advise is, you know, if you've observed that behaviour, there's a couple of steps you could take. You know, you can either take that person to one side straight away and go, you know, look, this is not acceptable, outline the behaviour. But I think it's also useful to check into the person who's been subjected and say, look, I did see what happened. I do, you know, I just want to let you know I'm here if you want to take that forward. I have had a conversation. If you want me to do anything, I'm here to support you. But I think, again, from what we hear, the most powerful way that line managers can do this is when, you know, if you're in, like, say, a team meeting and someone in that team meeting makes an inappropriate comment, is actually to straight away just make it clear that is not acceptable. And doing that in front of everybody, you know, that sends a very clear message, because again, a lot of stuff that we see in terms of sexual harassment, it's all about that bouncing off your peers, and it's seen as banter. And I think the more people that stand up and speak out, the better, especially men. You know, men can be the best ever allies around sexual harassment, because you know what some people are like. You know, like I say, they see it as a bit of banter, and if another man's going, you know what, this isn't funny, you shouldn't be doing this is unacceptable, it sends that clear message. So you don't have to wait for that complaint. You should be taking action to make sure that, you know, your people are very clear. We just don't do this here, you know, and this is what's expected. And if you want to behave like that, then you might want to look at working for a different organisation, because that's not how things roll here.
Right, thanks. We're just drawing to a close. Just one last question, I suppose, on training. I think training came across as a very important part of this. Is there sort of any training that you provide yourselves, or is that something that's on the open market? Julie.
So thank you for that. Obviously, I have to plug ACAS stuff. So we have got a key point session training that is going to be rolled out. I think bookings for those are now available on the ACAS website. It's a 2-hour key point session for organisations, but we also can come in and do bespoke training with your organisations. So we have senior business support advisors who could come into your organisation, do diagnosis, look at creating action plans, help you with that policy creation, all of that kind of stuff. So that is a service that we provide at ACAS. Again, the other thing that I didn't mention, Rebecca said that EHRC are updating their guidance. We're also going to be refreshing our guidance on the ACAS website. That will be ready by the 26th of October. And we will also be putting other tips and stuff like that. So, you know, just keep watching the ACAS website and the EHRC website. And, you know, it doesn't stop. This stuff doesn't stop on the 26th of October. So me and Rebecca are going to be doing as organisations a lot of stuff over, the coming months to just keep reiterating that message. So yeah, please feel free, look at our free guidance on our website, and if you want any bespoke training, just contact ACAS training team and they'll be able to tell you what the best solution is for you.
Thanks, Julie. I think I've linked to the toolkit in my answer to one of the Q&As. Hopefully that's got through to people. I don't know how this works. So if not, we'll send it out. And equally, when your guidance, Julie, is ready, we'll put that on that website and make sure that that's sort of a sort of go-to for the hospitality sector on all the key information. I think that's all the questions for now. Obviously, this, as you say, this issue doesn't go away on October the 26th. I was going to say it starts, but it doesn't start. It's been ongoing for many, many years, and there's equalities legislation in force. But yeah, just on that note, massive thank you to Julia and Rebecca. You've both been incredibly informative, and we're very, very grateful for your support. So yeah, please stay in touch, and to the members, thanks for listening, and we will get that information out to you as soon as possible. Well, thanks everyone. Have a great day.